All right, we're back. It is 1:55. And that one is faking me out now. Yeah, I know. 1:55, and we are reconvening. I don't see Mr. Tahir, so I'm just going to keep going. Len Aslanian, do I have that right? Yeah, Len Aslanian, Assistant City Attorney, City of South Pasadena. Oh, good.
Do not, so. All right, good morning, Chair Marcus, or good afternoon at this point, Chair and members of the board. Thank you for the opportunity to speak here today. My name is Len Aslanian. As was mentioned, I'm an Assistant City Attorney with the City of South Pasadena. My firm also represents the City of Sierra Madre, and you heard from Mayor Capocha earlier this morning. Given the dialogue that we had this morning about especially with some of the local government permittees, I frankly don't have a whole lot new to add to what was said today, but I will try and make a couple quick points and keep it short. South Pasadena also fully supports the goals of the Clean Water Act and the general approach of the board, and wants to make sure that the MS4 permit is implemented in the most effective way possible. We appreciate the board's receptiveness to the city's comments, and especially during the course of this permit drafting process. And we specifically support the board's deletion of the requirements for cities to implement control measures that go beyond what is included in an improved WIMP or EWIMP. But we remain concerned about the overall level of flexibility that's built into the permit, given the complexity and cost of implementing these projects. The WIMPs and EWIMPs are the first regional structures that could bring meaningful change to Southern California's stormwater problems, and of course we are in support of that. But as the board is aware, these projects are very ambitious, they are untested, and they are often based on a host of tentative scientific assumptions. And I think that is a big driver of some of the alarm, really, that you were seeing this morning from some of the local government representatives as they are being hit with these initial estimates from their consultants that reflect some pretty staggering costs. And as has also been discussed today, we don't know how those numbers will shake out, and certainly I understand that the board does not have any of those numbers in front of it right now. But bearing today's statements in mind, we would urge the board to really be continually mindful of the need for flexibility in the permits, particularly when it comes to the WIMP and EWIMP deadlines. And we know that the board and staff, as discussed today, have been mindful of these issues. And actually, I would point out that given that in the permit update that was released just last week, we noted that the proposed limit to request an extension of the WIMP and EWIMP deadlines was reduced from 180 days to 90 days before these deadlines fall. And we support that, although that is still more stringent than the original permit draft, which had a 45-day limit. And likewise, we would request the board add some clarifying language that gives cities greater opportunity to modify their WIMPs and EWIMPs and their implementation to reflect updated project monitoring data as that data becomes available. The bottom line is that South Pasadena and other local governments want these projects to work. We want to address the stormwater problem, but we also want to do it in a cost-effective manner and in a way that really is reflecting conditions on the ground. And we believe that flexibility that's built into the permit and as clear as possible is key to that. Thank you.
Thank you very much, and thanks for staying with us. Steve Mandoki, City Manager of Lawndale. Hi.
excuse me, Madam Chair, members of the board, thank you very much for having this hearing today. I am here on behalf of the city of Lawndale. It's a city in LA County. It's about 15 miles south of downtown LA. We're 34,000 residents in 2 square miles. And I had a number of items in my presentation that do deal with the estimates of the cost, which none of us seem to have the real numbers yet, which concerns me is that we have to approve a program or enter into a program where we don't know what it's going to cost us.
We've had numbers over
All
time,
over.
and it's up to you to come up with the plans. It's like you can't, this is one of those things where I know it sounds like we're disputing your consultant's numbers, but I would say I have a healthy skepticism about them because you can always come up with numbers on a plan that are terrifying to everyone. And the job of the city manager, I ran a public works department, is to figure out how to do it and to make that good faith showing, because I don't think you're going to choose to do the most expensive thing that doesn't yield result.
We can't. With the money we've lost through the state already and our budget, we have a $12 million.
We don't want you to, but cities around the country are figuring out how to do this, and cities within the county are figuring out how to do it. So I would have a skepticism about those numbers.
Well, at this point, I guess I'll need to rely on my consultant, and he was going to speak to the numbers. But the low estimate is about $2 million per year per square mile, and that's about a third of our operating budget. That equals about 7 of our 9 departments. That's all of our police contract with the County of LA. It would present a major hardship. We all agree we need to work on the watershed issues. But we are very concerned about the process and being put into a position where we really truly cannot fund it without really shutting down other operations. Other cities have expressed the same concerns, and I want to go on the record that Lawndale, of course, shares the same concerns also. We will want to comply, but at the same time, we also don't want to be penalized when we're not able to, because again, finances that are out of our reaches. And we have no revenue streams in the city. We're a small city. There's nothing new. We don't have auto dealers. We don't have shopping malls. We're like many cities.
But you could possibly be eligible for some of the disadvantaged community monies.
I don't know about that. But anyway, I wanted to go on the record saying, of course, Lawndale would like to see, we've talked about the iterative process, and I know I've heard that said it doesn't work, but I know our consultant has talked about that being something that should be considered and an option for the permit. And again, the city of Lawndale would like to go on the record requesting that and consideration of how this really would impact all the cities. And again, the process that's been extended to neighboring counties, San Bernardino, Riverside, Orange, Caltrans, why not extend that to the County of LA too and its permittees? So with that, I thank the board for your time.
Okay. Thank you. Thanks for joining us. Mr. Brousseau from Casqua.
Good afternoon, Chair Marcus, board members. My name is Jeff Brousseau. I'm the Executive Director for the California Stormwater Quality Association, or CASQA. I'm speaking on behalf of obviously of CASQA, but also Gerhard Hubner, who is the chair of our board. He couldn't be here today, so he extends his regrets on that. About 300 of CASQA's members are MS4 permit holders, and as a result, we've been very interested, obviously, in the revised draft order as it relates to receiving more limitations language, the RWLs, because we obviously see that it will provide guidance and structure and implementation of RWLs in permits for some time to come. I want to thank State Board staff for taking on a number of perplexing regulatory questions in this permit process and this petition process. It's not been an easy job, and we really feel for them. I think you're getting a sense of the complexity today again. We also want to thank them for their thoughtful review and drafting of the revised draft order. And thank you again for the ability to comment on it again today. CASQA generally supports the draft order and also generally supports the State Board's revisions as expressed in the revised draft order. There were certain revisions to the previous draft that CASQA found particularly helpful. We want to thank you again for those. We mentioned those in our June 2nd letter. There were a couple of other provisions that we asked for some changes on that we didn't get, but we understand, based on staff's presentation this morning, the reasoning behind those as well. CASQA appreciates excuse me, I've got a bit of a cold here, so I'm having a hard time breathing and talking at the same time. CASQA appreciates the progress made with respect to the State Board and the public's understanding of how difficult it is for municipal stormwater to not always, to not cause or contribute to violations of SWRCB limitations everywhere at all times for all pollutants. That's a pretty tall order and difficult to do perfectly. The revised draft order appears to recognize the difficulty here and accordingly seeks to provide regional boards with some discretion. So we obviously appreciate that as well. By the way, how much time have we got on this section? 3 or 5? I wasn't. It was 5. Okay. Was that 5 minutes already? Wow. 3. I got. Okay. Yeah. I appreciate that. CASCO appreciates the inclusion of footnote 142 on page 56, I think it is, that references CASCO's strategic compliance program language. We spent quite a bit of time on this trying to look at the permits around the state and crafting some language that includes the EWIMP and WIMP approach, but also includes the approach being taken in the San Francisco Bay Area and also in the Sacramento area as well. All these approaches to try and give more definition and rigor to the iterative approach or to the adaptive management approach. And we really appreciate the board recognizing that. Not endorsing it, obviously, but recognizing that it exists and noting that regional boards should take a look at that. And we hope that they do for those permits in the state that don't actually have alternative compliance pathways currently in them. CASCO does need to emphasize that the state board's general recognition of alternative compliance pathways is just really the first step towards dealing with this difficult issue of always complying with SWRCB limitations. And we're hoping that we can continue to work with you and stakeholders on other ways to constructively deal with that challenge. And so accordingly, we encourage the state board, regional boards, other industry stakeholders to continue the discussions with how water quality standards should be applied to stormwater. As aptly stated in the draft order, municipal stormwater management is an area of continued development, and with continued research and data evaluation, water quality standards may evolve and become more nuanced or sophisticated over time. CASCO is committed to working with the state board with respect to this need for ongoing data evaluation and towards modifying, as appropriate, the application of water quality standards to stormwater. And I should also say that we would support, if the board considers Ms. Purdy's recommended change to the revised draft, we would support that as well, as Norman DuPont mentioned as well. And with that, thank you.
Thank you very much, and I hope you feel better. Hi, Mr. Tahir? You asked for 10 minutes on behalf of your clients. 10, because you've had your clients talk too, so we thought you were talking for your clients, so 10.
Okay, I'll take it. Good afternoon, Madam Chair, Vice Chair, board members. My name is Ray Tahir, and I'm speaking on behalf of the cities projected on the screen. What I want to talk to you about is the primacy of the stormwater management program and the iterative process as a compliance determinant. The draft order still does not unequivocally affirm that the stormwater management program iterative process as a means of achieving non-strict compliance with water quality standards. Though the draft order upholds State Board Orders 9905 and 2001-15, it still contends that the iterative process is ineffective, something we heard earlier, and the courts have held that the iterative process does not excuse violations resulting from water quality standard exceedances, and we agree. But this still gives a false impression that the iterative process is not valid. Here's a reality check. The iterative process was ineffective because it was not even mentioned as a specific term in the 2001 LEMS4 permit, let alone defined or explained in it. You can't comply with a requirement if it isn't clear. The LA board is responsible for this. It had 10 years to reopen the MS4 permit to include a well-defined iterative process to meet water quality standards, but chose not to. Instead, it chose a complaint that didn't work. The regional board didn't even provide instructions for how the IP would work in the current 2012 MS4 permit, which references the iterative process. Unfortunately, the state board should also take some responsibility for the iterative process not working. It could have years ago developed an iterative process, a set of guidelines for inclusion in all MS4 permits in the state, but it chose not to. And if the iterative process is so ineffective, then why is it a feature in the state board MS4 permit for Caltrans and every MS4 permit in the state? Still, the State Board can correct this by adopting the North Orange County MS4 permits iterative process, which is well-defined and contains measurable and enforceable performance benchmarks to meet water quality standards. Here's another reality check regarding what the courts have said. The Ninth Circuit said in connection with the LA permit that the iterative process does not forgive or excuse water quality violations, but it was careful to also draw the distinction between the iterative process not forgiving violations and preempting them. Had the court meant that the iterative process is an invalid compliance mechanism, it would have contradicted its own decision in Browner versus Defenders of Wildlife. It would have ignored Clean Water Act Section 402PB3. It would have invalidated the Water Quality Orders 9905 and 2001-15 and voided the maximum extent practical standard, which exclusively applies to the SWMP and the iterative process. Let's talk about the maximum extent practical definition as defined by the board. And this is on your website, and the definition is right next to this very attractive picture. I need to redeem myself. And here's what it says. The MEP requires permittees to choose effective BMPs and to reject applicable BMPs only where other BMPs will serve the same purpose. The BMPs would not be technically feasible or the cost would be prohibitive. And this is per Water Quality Order 2000-11. MEP is a result of the cumulative effect of implementing, continuously evaluating, and making corresponding changes to a variety of technically and economically feasible BMPs that ensure the most appropriate controls are implemented in the most effective manner. This process of implementing, evaluating, revising, or adding new BMPs is commonly known as the iterative process. So MEP is mandated under the Clean Water Act, and the iterative process is connected to the MEP. They go hand in hand. This doesn't get any clearer than this. So the MEP and the iterative process are mandated under the Clean Water Act. So the upshot of the State Board's MEP definition is that it sanctions and validates the iterative process consistent with the water quality orders I just mentioned. The State Board does not have the flexibility to reverse itself on the iterative process. That was something that was mentioned in the draft order and in the previous draft order as well. Does not have that authority. State Board must make clear that the iterative process applicable to the stormwater management program is a valid, non-strict compliance approach for meeting water quality standards. Continue to obfuscate the iterative process would result in the unenforceability of compliance with water quality standards. Permittees have a right to know what their legally valid compliance options are. The SWMP iterative process is needed because of the impracticality of the WIMP-EWIMP option. The WIMP-EWIMP costs are infeasible for most cities. Recent EWIMP costs average $2 million per square mile. These are not my costs. They are not my costs. They were developed by several consultants in response to modeling instructions contained in the permit. It's the model that gave rise to these costs. And the model is not a good one. As Dr. Booth pointed out, you need a calibrated model that's based on outfall discharges over at least 5 years. This is why you have the bad costs, because you have a bad model. And perhaps Dr. Booth can shed some more light on this later on, should you ask him this question. The infeasible WIMP-EWIMP costs make it impossible to comply. There is no, by the way, iterative process or safe harbor to protect the WIMP or EWIMP cities against water quality violations detected through water quality monitoring. Here, the draft order is bipolar on the safe harbor issue. In several parts of the permit, it says that a safe harbor, like the iterative process, cannot forgive violations. Yet on pages 52 and 53 of the order, it says that a safe harbor applies to the WIMP-EWIMP during the planning phase. It begs the question, if the safe harbor only applies to the planning phase, then it must not apply to the implementation phase either. And if it does not, then what protects the WIMP-EWIMP permittees against violations in the event of a water quality exceedance? The cities, once again, have a right to know if a safe harbor exists or not. Further, the courts have said the safe harbors are invalid. The Ninth Circuit said safe harbors don't absolve, forgive, or excuse violations. In the 2006 decision, Fourth Appellate Court decision said in the city of Rancho Cucamonga versus Santa Ana Regional Board that safe harbors are not only illegal, but unnecessary because of Water Quality Order 9905, which was intended to omit safe harbors from MS4 permits. Intended to omit safe harbors from MS4 permits. Again, 9905 is this. Again, 9905 is the SWMP iterative process is a legally valid compliance determinant. There are other conflicts. The order allows a WIMP, E-WIMP permittee to meet water quality standards per Part 5A of the MS4 permit, while the WIMP, E-WIMP is pending approval. A problem, Part 5A applies, which deals with receiving water limitation compliance, only applies to the SWMP iterative process in keeping with 9905. Also, the order entitles a WIMP, E-WIMP permittee to MEP. Wrong. MEP only applies to the SWMP iterative process. And even if it did, the WIMP, E-WIMP would fail to meet the MEP standard because of economic and technical infeasibility. Non-stormwater discharges in MEP. The draft order and MS4 permit assert that municipal non-stormwater discharges are subject to MEP and are applicable to meeting TMDLs. Wrong. They are not. Per Clean Water Act Section 402PB2. The draft order and MS4 permit assert that technology standards apply to municipal stormwater and non-stormwater discharges. Wrong. Browner said that technology standards in Clean Water Act Section 1311 do not apply to municipal discharges. They only apply to industrial discharges. And I think you know this, Ms. Marcus. The conflicts render the order and the MS4 permit unenforceable. That's the bottom line. If cities are expected to spend millions of dollars on MS4 permit compliance, they have a right to clearly written, reasonable, and legally correct requirements. The State Board should not adopt the draft order and instead hold another workshop to correct these deficiencies and review the accuracy of the current model in predicting costs in response to identified BMPs. I apologize for those costs, but they didn't come from me. They came from the consultants, multiple consultants, several consultants. And all I was doing was basing those costs on what those consultants had presented for other E-WIMP subwatersheds and WIMP watersheds. To me, I always thought that the cost would only be about $500,000 per year per square mile. That was my feeling. I was totally shocked when I saw those costs, as were a number of cities. And by the way, those costs are not conceptual. They are specified in the permit based on instructions for the modeling. That's why you're getting uniform costs across the board for all E-WIMPs and WIMPs in the county. So I just wanted to make that clear and apologize for if I gave the impression that I was exaggerating. In any case, that's it. And thank you very much for the opportunity to present to you today.
No, thank you for going through it concisely. I have a few questions before you go, and I actually want, I don't know whether it would be one of you or Michael to talk about some of the issues here. I get the sense that there may well be differences on the law, but there are also differences of opinion in what the draft order actually says. And you had a lot of points in there, some of which that I actually want to give either Ms. Modwani or Mr. Wiles or Mr. Lawfer a chance to clarify for everybody listening so that I can understand where the disagreement is. I mean, there are a lot, let me count the ways, there are a lot of them. So,
I think there are several misunderstandings, and I don't know if I'll go through all of them now, but I do believe the order from a legal perspective is internally consistent, and that Mr. Tahir is misreading some of what we have put down in the order. Several things I can mention. I think he's reading our interpretation of what we said about our precedential orders differently than what we've actually said. We've explained that those precedential, although we're upholding 9905 and the language in there, we do not see 9905 as creating compliance with the receiving water limitations when an iterative process is followed. So that's one source of misunderstanding, I think. Another is that maybe there's some confusion about MEP versus the receiving water limitations compliance, two different issues. And with the receiving, both of them have a component that can be considered an iterative approach. In the receiving water limitations case here, the way this order is structured with the watershed management programs and enhanced watershed management programs is that implementation of those programs constitute compliance with the receiving water limitations. And from what I'm hearing from Mr. Tahir, he's reading it as only compliance during the planning phase, not following that, but I think the order is pretty clear. That's the main thrust of the order in many ways, that it's the implementation of a watershed management program or enhanced watershed management program that allows the permittee to be in compliance with the receiving water limitations while they're implementing the program. Otherwise, they would be required to strictly comply with those receiving water limitations and show compliance immediately. So I think there's some confusion there. I don't know that that fully addresses all the points that Mr. Tahir is making. I don't know if Phil or Michael, if you guys want to add to it.
You know, I think Emil did a great job covering the broad thematic issues. The only thing that I would address above and beyond that is just the evolution, if you will, of the concept of safe harbor. I think there were a lot of different concepts that Mr. Tahir was throwing out there, but essentially what you have, and this is something we've discussed extensively at the workshops on this, was that in 1999, this board affirmatively made a decision based on feedback from EPA to adopt as precedential language receiving water limitations language that omitted a safe harbor. And when Mr. Tahir refers to the Rancho Cucamonga decision, that was the lens through which the court was looking at what in that particular instance, the Santa Ana Regional Water Quality Control Board had done. It did not say that safe harbors were illegal. It in fact acknowledged the permit shield provisions of the Federal Clean Water Act and acknowledged the role that this board has in establishing those permit requirements. And again, this is on the receiving water limitation issue, separate and apart from the maximum extent practicable standard and how that plays out under the Clean Water Act. What you've seen and what the order goes to great lengths to document is a class of activities, whether it is development and implementation of EWIMPs or WIMPs, that your staff, having looked over the evolution of the stormwater program and having looked over the permit as developed by the Los Angeles Water Board and the extensive record before this board, a class of activities that should be entitled to a safe harbor. We are in fundamentally a different place than we were 16 years ago. I think everything else, like I said, Emil had at least hit on the thematic level, and we've extensively discussed before the distinction between the non-stormwater issues, which are not subject to the MAP standard under the Clean Water Act, but the effective prohibition language. So,
I'd like it to respond. Getting to what Emma mentioned earlier, that I somehow misinterpreted 9905. If I misinterpreted 905, so has this board, because it applies to Caltrans and applies to the other MS4 permits. Now, if you want to change that policy, then you can do so, but you cannot limit the applicability of 9905 to jurisdictions other than the County of Los Angeles. You can't do it. Regarding the safe harbor and the shield, going back to the Fourth Appellate Court, yeah, he's right. The court said that there is a shield. That shield is the LAMS4 permit, and that shield is a SWMP iterative process, not the safe harbor. And once again, could someone here please define what safe harbor means? There has to be a definition of it. So, and I think it's really important to know that. Again, cities have a right to know how to comply. If there is no safe harbor, which the enviros are advocating and which I agree with, then please, let's say so. Otherwise, we're going to end up in court. Thank you, ma'am.
Thank you. Do you want to comment on that? Help a little bit, because it's not, I think the answer is environmental concerns are concerned that there is a safe harbor as opposed to there isn't a safe harbor. So maybe it's just the wrong term of art, and I know you've tried to differentiate from the iterative process to this.
Right. So the only thing I was going to add to what Emil and Michael already said is that for those who are now find themselves more confused than they were before, we actually do in pages 10 to 17 of the draft order lay out this entire progression and specifically describe the terms that Mr. Tahir was using and using incorrectly and define them. And so if anybody who is listening to this or watching this, again, does find themselves confused, I would suggest they go back and read those pages, and Mr. Tahir may as well. It's section 2A of the order, where we describe the evolution, where we describe the distinction between MEP, the iterative process, safe harbor, and this new approach of alternative compliance paths.
Yeah, and I would just say Mr. Tahir just disagrees with you.
I don't see it. I mean, forgive me for saying this, but
And then this will be your last.
okay. Whole draft order is a tangle of confusion. I mean, it is. What you need to do then is take what you just said, those references in that section of the order, and make definitions out of it for inclusion in the MS4 permit, so we know. There's also confusion with regard to the adaptive management process. So if you would do that, that would clarify things up greatly and prove me wrong. I look forward to it, but you need to do that. Thank you.
All right, next we have Ashley Desai on behalf of the San Diego County, of San Diego County, from Larry Walker and Associates. Hi.
Hello, Chair Marcus and members of the board. My name is Ashley Desai. I'm from Larry Walker Associates, and I'm speaking on behalf of the County of San Diego today. They appreciate the opportunity to provide comments on the proposed order. The county is primarily concerned with the receiving water, the decisions regarding the receiving water limitations that's discussed in the proposed order, because it will set a precedent and provide direction to all regional boards requiring compliance with the receiving water language in MS4 permits. And the county feels that the inclusion of the existing receiving water limitation language in the permits has the potential to divert focus away from addressing the highest water quality priorities. While we appreciate the support in the proposed order for the alternative compliance pathway, it does not fully address the potential compliance issues with the receiving water limitations language. And that is really highlighted by the new footnote 100 that was added on page 37 of the change sheet, which talks about the fact that water body pollutant combinations not covered in a watershed management plan or enhanced watershed management plan would potentially be considered a violation of the receiving water limitations. And these pollutants that would end up, because the watershed management plans are focused on high priorities and things that TMDLs, 303D listings that are exceeding frequently, what this ends up meaning is that resources are potentially diverted to address an infrequent, low priority constituent because it might be a permit violation, because it's not in a watershed management program. And it also puts people in the situation of if there's a new objective or a new constituent that shows up, they could be potentially in violation. And so the county is concerned that this forces municipalities into diverting focus to chase down these infrequent exceedances rather than be able to focus on the things that are in their watershed management plans. This really appears to be counter to the intent of the watershed management approach to streamline and implement multi-benefit projects, which might address these pollutants in the future, but are considered a violation just because they're not in the watershed management plan. So we are hoping, request that the proposed order either direct removal of the problematic receiving water limitation language or provide modifications that clarify compliance for these constituents to avoid permittees being out of compliance. This could be accomplished by having receiving water limitations only apply to persistent exceedances or those that would result in a 303D listing. The county is also concerned about the removal of language on page 40, acknowledging that technical infeasibility and substantial hardship, including the ability, despite all reasonable efforts, to obtain funding. So you've heard this from a few other people. So the county felt that inclusion of this language was a critical recognition of the challenges faced by municipalities in obtaining funding for these plans, and that other challenges, such as site-specific constraints on best management practices, particularly infiltration BMPs. While LA has a lot of opportunities, San Diego County does not have as many opportunities for those, may limit the ability of receiving water limitations to be achieved despite the best efforts of the municipalities. These constraints need to be recognized in the proposed order. So the county requests that the deleted language be added back into the proposed order, or as some other commenters have mentioned, that some recognition that substantial hardship includes financial hardship. The county appreciates your consideration of these comments, and the county looks forward to continuing to work with you to protect the environmental integrity of our waterways. Thank you.
Thank you.
Can I address the first issue raised? So this was something that came up at the workshop, so we spent some time trying to think through it. The issue is that the WIMPs, EWIMPs ask for prioritization, and dischargers incorporate high priority control measures to address high priority water body pollutant combinations. There are some remaining, almost certainly, water body pollutant combinations where you're occasionally going to see an exceedance, but because they're lower priority, they may not be in the WIMP, EWIMP, and only those water body pollutant combinations that are addressed through the watershed management programs trigger the deemed compliance with the receiving water limitations. We did think about this. I think it's more of a theoretical concern in some ways than a practical one, because the dischargers always have the ability to ask to amend their watershed management programs to add a pollutant to address it, and the regional board can request them to. So I think in most situations, if there is something that's going to lead to a violation, the first step would be to amend the watershed management program and add it to it, and then it would be covered through that program.
And next, Melissa Thorne for the Port of Stockton and the City of Tracy.
Board members. I'm here, I'm Melissa Thorne from Downey Brand on behalf of the Port of Stockton, City of Tracy, and they are concerned about this because we're right in the middle of negotiating a new Phase 1, potentially Phase 2 permit for the entire Central Valley region with Pamela Creedon and her staff. And so we look at this as being a precedential order for that process and want it to be as clear as possible. The first thing I'd say is I support the anti-backsliding analysis, that there were no effluent limits in the previous permit, so effluent limits are the things that anti-backsliding applies to, so there really is not a need to get into the exceptions, but I understand the reasons for doing so and support that. I don't think that we should continue to rely on 9905 as the order, because that was based on an EPA objection to permits in 1998 based on the fact that those permits did not comply with Section 301B1C of the Clean Water Act. EPA was overruled on that then in the Defenders of Wildlife case in 1999 after 9905. So it was basically based on an unlawful premise. So I think we should try to get away from using 9905 as what we continue going forward, or at least include the concept of compliance over time. That sometimes it's going to take time, and I think the environmental community even understands that. I also think there's a little bit of a revised history here, because there was a discussion on page 13 of the order about significant confusion by MS4s, and in my letter of June 2nd, I gave you the reason for that confusion, because there were two specific letters that came, one from the LA region, Fran Diamond, the chair of that board, and one from Bob Schneider, the chair of the Central Valley Board, both of those letters saying, if you're in compliance with the iterative process, you are in compliance with the permit. So it wasn't a confusion thing. They were told straight out that if you complied with that, you were going to be in compliance with the permit. So I think people relied on these two letters, and now people are saying, no, you're not in compliance if you're in compliance with the iterative process. So I think the WIMP and EWIMP provisions in the draft order are similar to, but just more specific than the iterative process. It's just an iterative process on steroids. And I think that you should make this determination going forward from adoption about the deemed compliance and not historically. Because people that have the current 9905-esque language in their permits right now are potentially subject to 5 years of alleged violations where receiving water limitations are exceeded. So like the industrial stormwater permit, where you started now with a baseline going forward and you have then level 1s and level 2s that people will move into, if you could do that with this permit and say, moving forward, this is how we're going to interpret that language, but it's been unclear based on those letters in the past. And it's particularly problematic for Phase 2 permittees because there's no path for compliance in that permit, and there's a footnote in this draft order saying, we might get to that at some point, and they need to know how they can comply. You can't just leave them swinging in the wind. And for things like pesticides and copper, all those things that it's going to take a while, and municipalities don't really have authority to ban those things, or say you can't use tires that have zinc in our jurisdiction. It's just not realistic. And I also agreed with Ms. Desai's comment that you should specify that if you have a WIMP and EWIMP compliance coverage, that is a permit shield for other things that might be sporadic that come up, because we really want people to focus on the highest priorities but not feel like they're going to be in non-compliance for the other things. So as long as you prioritize and say we have 10 things that potentially are on our list, and we're going to do 1 through 3, and that's all we have the money for, the time to do in the first round, and then we're going to move on to these other things, that you should be covered under a permit shield for all of those things. And then the final thing is I'd put in my June 2nd letter that we really like some clarification on the need for doing a reasonable potential analysis before TMDL requirements are placed in a permit. And I gave lots of legal reasons for that in that letter. So that was another issue that was in the draft order. But I thank you. I understand that there's a lot of issues that you've been wrestling with for many years, and we like to see a good path forward. Thank you.
Thank you. That was very clear. Can you respond to the 9905 issue? Do we have to rely on 905, or are we just moving forward? I'm not quite.
Well, the issue with 9905 is that's where the language was established. But 2 years later, after the Browner decision was issued by the Ninth Circuit, this court was specifically asked to revisit the language in 9905 in Order 2001-15. That's the San Diego Building Industry Association case. And the history is explained in the draft order that's before you. But this board concluded at that point in time that compliance with water quality standards needed to be a centerpiece, regardless of whether or not it was required by the Clean Water Act. And the board was fully cognizant of that legal decision when it went down that path. And the board has been invited many times to essentially repudiate that. And the draft order before you today doesn't repudiate that, but it does provide alternative approaches, recognizing the difficulty that the municipalities have had with the iterative process as outlined in 2001-15 as well as 99-05.
Talk a little bit about how the language on receiving water limits applies to the other permits that folks raised.
Currently,
just be an indication of where we're going when their permit is revised as opposed to immediately applicable to their permit.
Right, so we're directing that they be revised. Currently, most of our Phase 1, I think all of our Phase 1 permits, as well as our Phase 2 permit, our Caltrans permit, which is the Phase 1 permit, has the 9905 language in them. And we have been interpreting that language consistent with what we say in here for some time. We have, some of them have reopeners specifically. I think Caltrans and Phase 2, both of which were adopted while the receiving water limitations proceedings were ongoing, have reopeners saying that if the state board takes a different direction, it can be reopened to incorporate those. Some of the Phase 1 permits probably do not have a reopener. But the expectation, the direction certainly that we're giving the regional boards is that in the next reissuance of those permits that they would consider this approach.
Good. The issue's repeated about multiple pollutants, but we've had this discussion in the recent trash amendments. I keep pointing out the work we did in our TMDL implementation in the Caltrans MPDS permit for stormwater, and the attempts there to engage the scientists and group BMPs as far as the pollutants that they address. John, could you make any comments to that? Because I feel that sometimes folks are overwhelmed by the list of pollutants, but there's a logical grouping of those pollutants when it comes. I'm the civil engineer here. There's a way to group them and manage them as groups, whether or not you list it on the WMP or not.
Well, there's a couple of issues intertwined here, and I will try and to sort them all out. The first issue is that by prioritizing your highest quality highest problems. We support that, but that doesn't mean that a lower quality, a lower priority shouldn't be included in your WIMP and shouldn't be addressed at some point. That's the concept of having a priority scheme, that you do the most important first. But it's different than saying nutrients is our highest priority, and that's the only thing we're going to address in our WIMP and EWIMP, and all other pollutants are low priority, and so we are not going to address them. That's a different concept than prioritizing and doing the most important first. And so we recognize that if you include a priority scheme in your WIMP and EWIMP, but it has a lower priority, so you're not addressing those primarily first, that they still have coverage under that. But if you have a scheme where you say, for example, trash is a low priority and we're not going to address it, then then it isn't covered under that shield of WIMP and EWIMP, and it has to be addressed on the on compliance with receiving water limits through the appropriate mechanisms, which are the non-WIMP and EWIMP approach.
In this case, now with the adopted amendments to the Ocean Plan Inland Surface Water Plan for trash, there's a narrative water quality objective for trash.
That's correct. Yes.
That is part of the clean, the standards for the state. So, in other words, you can't ignore standards.
And so then the other piece that tangles in this is that that what we attempted to do with Caltrans was to give higher priority to bundled BMPs that address multiple pollutants. We didn't require that they use a BMP train that addressed all the pollutants, but we gave them essentially more credit in terms of our evaluation for those that did bundle it, so that those rise up to the top. So there's another piece of that puzzle, which is looking at all of your pollutants. Even if it is a lower priority, it may be that when you're designing your BMPs, you can evaluate a BMP train that takes care of both higher and lower priority pollutants at a significantly less cost and time than doing the highest and then coming back a few years later and doing the next one, and coming back a few years later and doing the next one. So those concepts are in there. That's the pieces of that puzzle.
What frustrates me about the misunderstanding is that is the spirit of watershed management, my friends. If you're actually going to do a watershed management plan, you're going to address all of the standards. You're going to deal with all of them. And if you're leaving something because it's a low priority and it comes back to bite in 20 years, then you didn't do a very good job at your watershed management plan. So it gets into some of the technical aspects of it, and forgive me because I get out in front a little bit because I'm one of those water nerds, or get into the details of it. And I know that our elected officials, city managers, and decision makers don't get all those details, and it looks overwhelming. But it's not. If you're doing it right, it shouldn't be an overwhelming issue at all.
Right, and if I can add a friendly asterisk, if new things come up, as Ms. Thorne said, you can ask to amend it.
Yeah, that's right. Well, and that's the beauty of it, too. The watershed management plan has to have an adaptive component to be real. Right, exactly.
Right, thank you. That was helpful. That's the end of our individual speakers. So now I'll move to the two closing panels. Again, the LA Waterkeeper, NRDC, and Heal the Bay.